Welcome back to the Deep Dive, the place where we take these really dense, complex, and foundational texts and, well, we try to pull out the crucial knowledge you need.
And today we have a big one, a really big one.
Absolutely. We're tackling the constitutional bedrock of the world's largest democracy, India. Specifically, its promise of individual liberty.
That's right. We're diving headfirst into Part 3 of the Indian Constitution, which runs from Article 12 all the way to 35. And this isn't just some dry list of rules.
No, not at all. It's a massive philosophical statement, a legal mandate that really defines the entire relationship between a person and the state.
It really does.
And as soon as we started digging into the sources, the first thing that hits you is just the sheer scale of the protection here. It's huge.
It is. The Indian fundamental rights are often called the Magna Carta of India.
Right. And you see why. They're incredibly detailed, often way more elaborate than, say, the U.S. Bill of Rights.
Which is funny because the Bill of Rights was actually a huge inspiration for it.
Exactly. But the detail is where the real story is. So our mission today, it's not just to give you a summary.
No, we're going to try and synthesize the actual constitutional text with some pretty deep legal commentary to get at the practical power and, honestly, the political tension that's baked into these rights.
Not just what they are, but why they're called fundamental.
And maybe even more important, how they're actually enforced against this, colossal machine that is the state.
I love that. So let's start there. If this is the foundation of political democracy, as the sources all say, what was the big idea? What was the philosophical purpose the framers were aiming for?
At its core, it's really about stopping tyranny in its tracks. These rights are there to promote the ideal of, political democracy.
By putting limits on the government.
Exactly. They act as a massive check on the arbitrary use of power, both by the executive, the government and its agencies, and by the legislature, the people making the laws.
So if the government tries to do something, I don't know, unfair or just illogical, these rights are basically the weapon you use to fight back.
That's a perfect way to put it. The end goal, the big prize, is to establish a government of laws and not of men.
I've heard that phrase. What does it really mean in practice?
It means the law itself is king, specifically the fundamental law of the Constitution. It has to be sovereign so that no single person, no political party, can just act on a whim outside the boundaries that have been set.
That sets the stage perfectly. So to guide everyone through this, how are we going to structure this deep dive?
Okay, so we'll start with the basic framework, the definition, the purpose, and then we have to talk about the really dramatic history of the right to property, which was actually deleted.
A huge story there.
A huge story. Then we'll get into the operational stuff, the features, the limitations, the role of the Supreme Court as the sort of ultimate guarantor. And then Article 12, which defines the state. Who are you actually fighting against? And finally, we'll dedicate a big chunk of time to the right to equality in Article 14. We'll look at the rule of law and then this really startling list of exceptions where equality, it doesn't quite apply.
Fantastic. That sounds like a great roadmap. Let's start at the beginning then, the foundation.
Let's do it.
Okay, so the absolute basics. Constitutional location. You said Part 3. What articles we're talking about here?
We're looking at Part 3, and it covers Articles 12 to 35. And you have to understand, these articles are probably the most litigated, the most argued over part of the entire Indian Constitution.
Why is that?
Because they touch everything. They impact everyday life in a way that, articles about government structure just don't.
Right. And let's drill down on that word fundamental. Why that specific label? I mean, what makes these rights different from any other law?
There are really two reasons, kind of layered on top of each other. The first is purely legal. They're guaranteed by the fundamental law of the land, the Constitution itself. They're not just some ordinary law that a government can change with a simple majority vote. They are, for lack of a better word, entrenched.
So they're harder to change. What's the second reason?
The second one is more philosophical. It's the idea that these rights are absolutely essential for the all-round development of an individual.
All-round development. That sounds a little vague. What does that actually mean in practice?
It's meant to be holistic. It covers the material side of things, so your ability to have a livelihood, the intellectual side, so freedom of thought and expression, the moral side, living an ethical life, and the spiritual side, your personal beliefs.
So their argument is that without these guarantees, a person can't really flourish.
Exactly. The framers believe that without these specific protections, full human flourishing, which should be the goal of any free society, is basically impossible.
Okay, that makes total sense. So Essential to being human and baked into the highest law of the land. Fundamental feels right. But you mentioned this list hasn't always been the same. There was a huge politically charged change.
Oh, yes, a massive one. See, when the Constitution was first adopted, there were actually 7 fundamental rights.
7. So one is missing now.
Correct. And the story of that missing right is really the story of the Indian Constitution's biggest tension.
Which is?
The constant balancing act between individual liberty, which it inherited from, Western liberal traditions, and the urgent national need for socioeconomic change, things like land reform, poverty reduction.
And this tension, it all came to a head over the right to property.
Absolutely. The right to property, which was originally Article 31, was a political and legal bombshell from day one.
Why was it so controversial?
Because the government, in its mission to build a more socialist society, needed to do things like nationalize industries and, more importantly, redistribute land from large landowners to the landless.
But every time they tried, the property owners would sue.
Exactly. They'd go to the Supreme Court and use Article 31 to challenge the government's action, arguing their fundamental right to property was being violated, and often they'd win.
So this led to some famous showdowns, right? The courts versus Parliament.
Some of the biggest in Indian legal history. You had cases like Galaknath v. State of Punjab in 1967, where the Supreme Court actually said that Parliament had no power to amend fundamental rights at all.
Wow. So the court basically drew a line in the sand.
A very firm line.
Oh.
And this kicked off decades of what you could only call constitutional warfare between the judiciary and the legislature. Parliament would pass an amendment to get around a court ruling, and the court would find a new way to strike it down.
So how did this finally get resolved? Or did it?
Well, it was temporarily settled, you could say. It all culminated in the government making a drastic move. They decided to just delete the right to property from the list of fundamental rights entirely.
They just removed it.
Yep. This was done through the 44th Amendment Act of 1978, a landmark moment.
Now, this is a really important distinction because
Right.
it wasn't destroyed, right? It was just moved. So what is its status now?
That's the key. It was converted into a legal right. It now exists under Article 300A in Part 12 of the Constitution.
And what's the practical difference for an ordinary person?
The difference is profound. The state still can't just take your property arbitrarily. It has to follow a legal procedure. But, and this is the big but, if your property is taken, you can't go directly to the Supreme Court anymore under Article 32 and claim a violation of your fundamental rights.
So what do you do?
You have to go through the lower courts and argue that the procedure was illegal, not that your fundamental right was violated. It's a much, much higher bar to clear for the citizen.
That one change must have massively strengthened the hand of the state.
It did. It allowed the government to push forward with large-scale land reforms and nationalization without this constant fear of being immediately blocked by the courts on fundamental rights grounds.
So it was a clear choice, prioritizing the collective good over this one specific individual right.
You could say it was a necessary, if controversial, move for a young country trying to tackle immense poverty and inequality. And that leaves us with the 6 categories of fundamental rights that exist today.
Okay, let's lay them out. Let's go through the current list of 6, and maybe we can spend a bit more time on that last one, the one that's really the enforcement tool.
Sounds good. So first you have the right to equality. That's Articles 14 through 18. This is the big one on non-discrimination, religion, race, caste, sex, place of birth. It also abolishes untouchability and titles.
A huge social reform mandate right there.
Absolutely. Second is the right to freedom, Articles 19 to 22. This is where you find your core civil liberties, the famous 6 freedoms: speech, assembly, association, movement, residence, and profession.
The ones that really define a free society.
They do. And it also includes the really critical protection of life and personal liberty and the right to elementary education.
Number 3.
Right against exploitation. Articles 23 and 24. This is a direct attack on historical injustices. It prohibits human trafficking, forced labor, and child labor in factories and hazardous jobs.
So it's about basic human dignity.
Yes. Fourth, the right to freedom of religion. Articles 25 to 28. This guarantees freedom of conscience and the right to freely profess, practice, and even propagate your religion.
But with some limits, I assume.
Oh, yes. It's subject to public order, morality, and health. The rights are never absolute.
Okay, what's 5th?
Cultural and educational rights, Articles 29 and 30. These are designed specifically to protect minorities. It secures their right to conserve their own language, script, and culture.
And it gives them the right to set up their own schools.
Exactly. To establish and manage their own educational institutions. It's a key protection.
All right, and that brings us to the sixth. And you said this one is the ultimate safeguard.
It is. Number 6 is the right to constitutional remedies, Article 32. This is the one that gives all the other rights their teeth. It is the right to go directly to the Supreme Court to get your fundamental rights enforced.
Okay, let's pause here, because this is the enforcement pipeline. The sources mention these things called writs, like habeas corpus and mandamus. We need to break down what these actually are. They're the tools, right?
They are the tools, the judicial tools that turn a right on paper into a government action in reality. Without them, the rights are just promises.
So let's go through them. What's the first one? Habeas corpus. Sounds like something out of a magic spell.
It does a bit. It's Latin for you may have the body. It's the great writ against illegal detention.
So if someone is arrested and you think it's unlawful?
Yes. The court issues an order to whoever is holding the person, a police officer, even a private person, commanding them to bring that person before the court. The judge then examines if the detention is legal. If it's not, they order immediate release.
So it's the fundamental check on police power.
It's the ultimate guarantee against being locked up and having the key thrown away.
Okay, what about the next one? Mandamus.
Mandamus is Latin for we command. This is a command from the court to a public official or a public body telling them to do their job.
To do a public duty that they've refused to do.
Precisely. Let's say your local municipality is legally required to maintain the roads, but there's a giant dangerous pothole they've ignored for months. You could petition for a writ of mandamus to compel them to do their duty and fix it.
That's incredibly practical. Okay, what's next?
The next two are kind of a pair, prohibition and certiorari. They're both aimed at lower courts or tribunals.
How so?
Prohibition is preventive. It's issued by a higher court to a lower court to stop it from hearing a case that is outside its jurisdiction. It nips the problem in the bud.
So it stops an illegal action before it's completed?
Correct. Certiorari, on the other hand, is curative. It's Latin for to be certified or informed. It's issued after a lower court has already made a decision. The higher court can use it to quash or nullify that decision if it was made without jurisdiction or involved in error of law.
So prohibition prevents, certiorari cures.
You've got it. That's the perfect summary.
And the last one, quo warranto.
This one means by what authority? It's a writ the court uses to investigate the legality of a person's claim to a public office.
So if you think someone got a government job they weren't qualified for, or through illegal means.
Yes. The court can demand that person show what legal authority they have to hold that office. If their claim is found to be invalid, the court can remove them. It's a check on cronyism and illegal appointments by the executive.
That is an incredibly powerful toolbox. So Article 32 isn't just a right, it's an armory. It makes the Supreme Court every citizen's personal bodyguard.
That's why Dr. B.R. Ambedkar, one of the key architects of the Constitution, called Article 32 the very heart and soul of the whole thing. Without it, the rest is meaningless.
Okay, that gives us the framework. Now let's get into the nitty-gritty. The features, the limits, the exceptions. Because a common mistake is to think of rights as absolute, black and white. But that's not the case here, is it?
Not at all. And that's maybe the most important characteristic to understand. Indian fundamental rights are qualified, not absolute.
Meaning they have built-in limitations.
Yes. The state is allowed to impose what the Constitution calls reasonable restrictions on these rights.
For what reasons?
Things like public order, national security, decency, morality. For example, your freedom of speech doesn't give you the right to incite a riot. The state can reasonably restrict that.
But that phrase, reasonable restrictions, seems like a huge gray area. Who gets to decide what's reasonable? The government.
That's the crucial question. And the answer is the judiciary. The courts have the final say.
So if Parliament passes a law that restricts a right, someone can challenge it in court.
And they do, all the time. The court will then examine the law. They'll apply tests. Is the restriction proportional to the problem it's trying to solve? Is there a less intrusive way to achieve the same goal? It's this process of judicial review that prevents the government from using public interest as a blank check to take away rights.
So because the rights are justiciable, enforceable in court, the judiciary, especially the Supreme Court, really becomes the guardian.
A defender and the guarantor.
Yes.
And as we said with Article 32, you can go straight to the top. You don't have to start at the bottom and work your way up the court system, which underlines the urgency.
But even with the Supreme Court as the guardian, Parliament still has the power to amend the Constitution itself. So Are the rights really safe from being changed or even removed by a powerful government?
That is the million-dollar question in Indian constitutional law.
Hmm.
And the answer is complicated. The rights are not permanent in the sense that Parliament can amend them.
With a special majority vote.
Right? It's not easy, but it can be done. So they aren't set in stone. However, and this is the biggest however in the Constitution, this power is limited by the basic structure doctrine.
The ultimate constitutional safety net. We have to unpack this. Why did the court feel the need to invent this doctrine?
Well, it goes back to that conflict we talked about between Parliament and the judiciary. For years, Parliament kept passing constitutional amendments to overturn Supreme Court rulings that protected fundamental rights. It was a power struggle.
So the court needed a final trump card.
It did, and it unveiled it in 1973 in the landmark Kesavananda Faradi case. The court essentially said, okay, Parliament, you can amend any part of the Constitution you want, but you cannot touch its fundamental core features. You cannot destroy its basic structure.
And what's included in that basic structure?
The court didn't give an exhaustive list, but it includes things like democracy, secularism, the federal structure, and critically, the fundamental rights framework itself.
So even if a government has a massive two-thirds majority in Parliament, they can't use it to, say, abolish the right to equality or turn India into a non-secular state.
That is the idea. The basic structure doctrine acts as the non-negotiable soul of the Constitution, placing it beyond the reach of temporary political majorities. It's what makes the core of the fundamental rights effectively permanent.
Okay, that's a huge concept. Now let's talk about accountability. These rights are guarantees against the state, so we need to be very clear about who or what the state is. This is all laid out in Article 12, and the definition is surprisingly broad.
It has to be. In a modern welfare state like India, government power isn't just in a minister's office in Delhi. It's everywhere. It's delegated to hundreds of agencies, corporations, local councils.
And if the rights only applied to the central government, it would be easy to get around them.
Very easy. You just outsource the function to another body. So Article 12 casts a very wide net.
So what are the four main branches that it includes?
First, the obvious one, the union government. That's the executive, the president, the cabinet, and parliament.
Makes sense.
Second, the state government. Same thing at the state level. The governor, the state cabinet, and the state legislature.
Also straightforward.
Third, local authorities. This is the government closest to the people. Municipalities, village panchayats, district boards, port trusts, and so on.
Okay, and then there's the fourth category, the one that causes all the debate.
The crucial one, other authorities. The Constitution deliberately leaves this term undefined.
Why? To give the courts flexibility.
Exactly. It allows the judiciary to interpret the term and expand the definition of state as new forms of government power emerge over time.
So this other authorities category is where things get interesting. It means bodies that might look like private companies are actually considered the state. How do the courts decide?
Well, the Supreme Court has developed a whole set of tests over the years. Most famously, in a case called Ajay Haja, they look for signs of being an instrumentality or agency of the state.
What kind of signs?
Things like deep financial control. Is the government providing all or most of the funding? The classic example would be a public sector undertaking like SAIL or ONGC.
The big state-owned companies?
Right. They also look at the function. Is the body doing something that's of public importance, something a government would normally do? Is it a monopoly that's been granted by the state? Is there deep and pervasive government control over how it's run?
So this is why a massive entity like the Life Insurance Corporation, LIC, or the Oil and Natural Gas Corporation, ONGC, which seem to operate like any other business, are still bound by the fundamental rights.
Precisely. So if LIC were to have a hiring policy that discriminates on the basis of religion, that would be a violation of Article 15, and you could challenge it in court just as if it were a government ministry.
That's a game changer. But what about private bodies?
This is where it gets even broader. The courts have held that this can even extend to private bodies that are working as instruments of the state.
How does that work?
Say the government contracts a private company to run a public hospital or school. While that private company is performing that public function, it is also bound to respect fundamental rights. It can't discriminate in admissions, for example.
That vastly expands the reach of accountability, especially now with so many public-private partnerships.
It does. It ensures that the government can't simply privatize a function to escape its constitutional obligations.
Okay, so we've defined the state. Now let's talk about the weapon you use against it. Article 13 and this idea of judicial review.
Article 13 is the engine of judicial review. It lays down what's called the void laws doctrine.
Which
It
says,
says any law, whether it was made before or after the Constitution came into effect, which is inconsistent with or takes away a fundamental right, shall be, to the extent of that inconsistency, void.
it's null and void. It has no legal effect.
Exactly. So this article is what gives the Supreme Court under Article 32 and the High Courts under Article 226 the explicit power to strike down a law passed by Parliament if it violates Part 3. They're the constitutional gatekeepers.
And the term law in this article is also defined very broadly, isn't it?
Incredibly broadly. It's not just an act passed by Parliament.
So what else does it include?
It covers pretty much any command that comes from the state. So permanent laws from legislatures, of course, but also temporary laws like ordinances issued by the president or a governor.
Which have the force of law for a short time.
Right. It also includes delegated legislation, all those rules, regulations, bylaws, and notifications that government departments issue.
And most radically, it includes something else.
Yes. And this is crucial for social reform. It also includes customs and usages that have the force of law in India.
Wow. So if a long-standing social custom, a tradition, violates a fundamental right,
Article 13 says that custom is void. Think about it in the context of Article 17, the abolition of untouchability. If a community has a custom that prevents certain castes from using a public well, that custom is unconstitutional and illegal under Article 13.
that's revolutionary. It allows the Constitution to reach into society and challenge these deeply entrenched, often oppressive traditions.
It's the Constitution's clear mandate for social transformation, not just political freedom.
Okay, but let's circle back to that tension between Parliament and the courts. You said an amendment isn't technically an ordinary law under Article 13. So how did the courts stop Parliament from just amending Article 13 out of existence?
This brings us right back to that incredible case, Kesavananda Bharati. The Supreme Court had to perform a bit of a legal masterstroke. They conceded that, yes, a constitutional amendment isn't a law in the narrow sense of Article 13.
So they gave Parliament that point.
They did. But then they immediately introduced the basic structure doctrine as a higher inherent limitation on Parliament's power to amend anything.
So even though Article 13 doesn't apply directly to an amendment, the basic structure doctrine does the same job, just at a more fundamental level.
That's it exactly. The court created a new level of scrutiny. An amendment can't be challenged for violating a specific right under Article 13, but it can be challenged and struck down if it damages or destroys the basic structure of the Constitution. So judicial review still stands, even against the highest form of lawmaking.
Incredible. Okay, let's shift gears a bit. Let's talk about who gets these rights. Are they for everyone on Indian soil or just for citizens?
A really important question, and they are definitely not universal in their application. The Constitution makes a very clear distinction between rights that are only for citizens and rights available to all persons.
And all persons can include foreigners and even companies.
Yes, foreigners and legal persons like corporations.
Okay, so which are the rights that are exclusively for Indian citizens? I'm guessing they're the ones tied to political life.
You've hit the nail on the head. They are the rights that relate to being part of the Indian political and social community. There are 5 of them.
Let's list them.
First, Article 15. That's the one prohibiting discrimination on grounds of religion, race, caste, sex, or place of birth. That's seen as an internal social contract.
Right.
Second, Article 16. Equality of opportunity in public employment. Government jobs are for citizens.
Makes sense.
Third, Article 19. The 6 freedoms we talked about,
Yeah.
speech, assembly, movement, and so on. These are the core political rights for participating in the democracy.
Fourth and fifth.
Articles 29 and 30. These are the cultural and educational rights for minorities to protect their language and culture and run their own institutions. Again, this is about the internal cultural fabric of the nation.
So just to be clear, if a tourist from, say, Canada feels the police have unfairly restricted their movement within a city, they can't claim a violation of Article 19.
Correct. But, and this is important, they can still claim a violation of Article 21, the protection of life and personal liberty.
Ah, so all the other rights are for everyone.
Pretty much. Article 14, equality before the law. Articles 20 and 21, which are crucial protections in criminal law. And Articles 23 through 28, the rights against exploitation and for religious freedom, those are available to everyone on Indian soil.
With any exceptions.
Just one, and it's a logical one.
Yeah.
Enemy aliens. During a time of war, a citizen of an enemy country wouldn't have these protections.
So the protection of life, Article 21 is a true human right, not just a citizen's right. That's a powerful statement.
It's a very strong liberal statement at the heart of the Constitution.
But even for citizens, as we've said, the rights aren't absolute. They can be restricted, and in some extreme cases, even suspended.
Yes, under very specific circumstances, usually related to national security or discipline.
Let's start with the need for discipline within the state's own forces.
Right. So Article 33 gives Parliament the power to restrict or even take away the fundamental rights of the members of the armed forces, the police, and intelligence agencies.
And what's the logic there?
It's purely functional. You can't run an army if soldiers can claim a fundamental right to form a union or publicly criticize their orders under freedom of speech. Discipline and operational effectiveness have to come first in those specific contexts.
Okay, that makes sense. What about a more extreme situation, like martial law?
The rights can also be restricted when martial law or military rule is imposed in an area, but this is very specific. It can only be done to restore order in a disturbed region, and it's temporary.
But the most sweeping suspension of rights happens during a national emergency. Now, this is a really sensitive topic in India because of how it was misused in the past.
Hugely sensitive. The emergency declared in the 1970s was a dark chapter, and it led to major constitutional reforms to prevent that kind of abuse from ever happening again.
So how does it work now? How does the Constitution handle the suspension of rights during an emergency?
The rules were completely overhauled by the 44th Amendment in 1978. The biggest change was the creation of what I'd call an unbreakable core of liberty.
An unbreakable core. What's in it? Which rights can never be taken away, even if the country is at war?
The rights under Articles 20 and 21. These can never be suspended.
Let's remind ourselves, Article 21 is the right to life and personal liberty.
Yes, the right not to be arbitrarily killed or detained by the state. And Article 20 offers protection against things like being punished under a retrospective law or being forced to incriminate yourself.
So the 1978 amendment basically said that even in the worst crisis, the state has to maintain a basic level of human decency and legal fairness.
Precisely. This was a direct response to a very infamous Supreme Court case from 1976 during the emergency, where the court had shockingly ruled that the right to life itself was suspended. The amendment made sure that could never happen again. The doors of the court must always be open to protect a person's life and liberty.
A lesson learned the hard way. What about the other rights, like freedom of speech under Article 19?
The rules for suspending Article 19 were also made much stricter. The 6 freedoms under Article 19 are now suspended automatically only during an external emergency.
Meaning a war or an attack from another country.
Yes, but, and this is crucial, they are not suspended during an internal emergency that's been declared because of an armed rebellion within the country.
Why is that distinction so important?
Because it prevents a government from declaring an emergency over internal protests or dissent, and then using that as an excuse to shut down freedom of speech, assembly, and the press. It ensures that even in a crisis of internal conflict, the channels for political opposition and debate remain open.
So you have this layered system, an inviolable core with Articles 20 and 21, and then strict conditions for suspending Article 19. It's a system that has clearly learned from its own history of crisis.
A very deliberate and very wise response to potential overreach of power.
All right, this is fantastic. For our final and deepest section, let's turn to the foundation of it all, the very first right in the list, the right to equality, Article 14. It sounds so simple on the surface, but the sources show it's actually a really complex dual concept.
It is the linchpin of the entire structure. Article 14 states, very simply, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. The key is understanding both halves of that sentence. They're not the same thing.
Okay, let's break them down. What's the first part? Equality before the law.
This idea comes from the British rule of law tradition, and it's what you'd call a negative concept.
Negative in what sense?
It means the absence of something, specifically the absence of any special privileges for anyone. It commands that everyone, from the prime minister to a street vendor, is equally subject to the ordinary law of the land and will be tried in the ordinary courts. No one is above the law.
So it's about forcing the state to treat everyone the same when applying a law, regardless of who they are.
That's the negative command. Don't discriminate. But then you have the positive part.
Equal protection of the laws.
Right. And this concept comes from the American Constitution. And it's a positive concept. It's based on the realization that in real life, people are not all equal. They have different circumstances, different levels of wealth, education, opportunity.
So treating them all identically might actually be unfair.
It could be. So this part of the article means that there must be equality of treatment under equal circumstances. It's the idea that like should be treated alike and unlike should be treated differently.
And this is where the government gets the power to make laws that, say, help disadvantaged groups. It's the basis for affirmative action and other social policies.
Precisely. Article 14 forbids what's called class legislation, which is when you arbitrarily pick a group of people for special treatment without any good reason. But it permits reasonable classification.
And we're back to that word reasonable. So how do the courts check to make sure a classification is reasonable and not just a sneaky way to discriminate?
The Supreme Court has laid down a two-part test that any classification must pass, and it has to pass both.
What's the first test?
Test 1, intelligible differential. That's a bit of legal jargon. It just means there has to be a clear, understandable difference that distinguishes the people you've put in a group from the people you've left out. The basis for the classification must make sense.
And the second test?
Test 2, rational relation. This difference, this differential, must have a logical connection to the goal of the law you're trying to pass. The classification has to actually help you achieve your objective.
Okay, an example would really help here.
Sure. Think about income tax. The law creates different tax brackets for different income levels. People with higher incomes pay a higher percentage of tax.
That's a classification.
It is. Does it pass the test? First, is there an intelligible differential? Yes. The difference is the amount of income a person earns. Very clear.
And the rational relation.
The objective of the law is to raise revenue for the state in a progressive way and reduce inequality. Taxing people based on their ability to pay has a direct, rational relation to that goal. So it's a valid classification.
What would be an invalid one?
Imagine a law that said, all people with blue eyes will pay 10% less tax. The intelligible differential is their eye color. But what's the rational relation? What government objective is achieved by giving a tax break based on eye color? None. It's arbitrary. The court would strike it down instantly.
That makes it perfectly clear. It's a powerful tool for the courts to ensure fairness.
It is. And this first part of Article 14, equality before the law, is deeply connected to the work of a famous British jurist, A.V. Dicey, and his doctrine of the rule of law.
Right. What were Dicey's key principles that were so influential here?
Dicey laid out three core elements that he felt defined the British system. First, the absence of arbitrary power. This means no one can be punished unless they've broken a specific law, proven in a regular court.
Yeah.
The government can't just act on a whim.
Sick.
Equality before the law. The principle we've just been discussing. Everyone is subject to the same ordinary law.
And the third one, this one was different, I think.
Yes. The third was the primacy of individual rights. Dicey's argument was that in Britain, the Constitution wasn't the source of people's rights. Instead, the rights came first, from common law and court decisions over centuries, and the Constitution was just a result of those pre-existing rights.
So how did India adapt this model? Did it take all three?
It took the first two completely. Absence of arbitrary power and equality before the law are absolutely central to Indian constitutionalism, but it had to completely reverse the third element.
Why the reversal?
Because in India, the Constitution is, without a doubt, the source of individual rights. Unlike Britain with its unwritten constitution, India's rights are explicitly written down, granted, and guaranteed by that single, supreme document. It's a system based on constitutional sovereignty, not parliamentary sovereignty.
And Article 14, embodying this rule of law, has a special status now, doesn't it?
It does. The Supreme Court has held that the rule of law, as captured in Article 14, is a basic feature of the Constitution. And that means Parliament can never amend the Constitution in a way that would destroy it.
So now we come to the great paradox. Article 14 is a basic feature, the bedrock of equality, and yet it's not absolute. There are some very significant exceptions where it just doesn't apply.
Yes, and this is where you see the pragmatism of the Constitution. It's a balancing act. Equality is the ideal, but the practicalities of governing sometimes require specific immunities.
Let's start with the top. The immunities given to the highest offices under Article 361.
This covers the President of India and the governors of the states. They're given certain protections during their time in office.
What kind of protections?
Well, first, for their official acts, they are not answerable to any court. This is to protect the integrity and independence of their decision-making process.
So you can't sue the president for a decision he made as president.
Correct. Second, no criminal proceedings can be started or continued against them while they are in office. They can't be arrested or imprisoned.
So if they commit a crime, they have to wait until they leave office to be prosecuted.
Yes. The accountability is deferred, not denied, to protect the dignity and functioning of the office itself. And even for their private personal acts, if you want to sue them in a civil case, you have to give them 2 months prior notice.
So we see a similar functional immunity for lawmakers, right? MPs and MLAs?
Do. Under Articles 105 and 194, they have absolute immunity for anything they say or any vote they cast inside the legislature.
This is legislative privilege.
Exactly. It's essential for ensuring they can have free and fearless debates without the threat of being sued for defamation for something they said on the floor of Parliament.
And there's also an exception for the media reporting on these debates.
Yes, under Article 361A, it protects anyone who publishes a substantially true report of the proceedings in Parliament or a state legislature. It's an exception to equality that actually promotes democratic transparency.
Then there are the international exceptions. Diplomats.
Right. Under international law, foreign sovereigns, ambassadors, and diplomats have immunity from both criminal and civil cases in Indian courts. The UN and its agencies also enjoy similar immunities.
Okay, those all seem like functional, necessary exceptions for the machinery of state and international relations to work.
Right.
But there's one final exception that's much more controversial, much more philosophically challenging. Article 31C.
Yes, Article 31C. This is the clause that basically says socialist goals can sometimes trump fundamental rights. It's the most explicit statement of the Constitution's dual personality.
Dual personality.
Liberal on one hand, guaranteeing individual rights, and socialist on the other, mandating broad socioeconomic transformation for the greater good. And sometimes those two personalities clash.
So how does Article 31C work as an override?
It says that if the government makes a law to implement certain directive principles of state policy, specifically Article 39B, about distributing resources equitably, or 39C, about preventing the concentration of wealth.
The big socialist goals.
The big ones. Then that law cannot be challenged in court on the grounds that it violates Article 14, the right to equality.
So if the government nationalizes an entire industry to prevent wealth concentration, the owners can't go to court and say, this is unequal, you're treating us differently.
That's precisely it. The path to an Article 14 challenge is constitutionally blocked. It can also block challenges under Article 19, the right to freedom of profession.
That's a massive exception. It creates a clear hierarchy.
It does. The political statement is clear. When there is a direct conflict between certain fundamental individual rights and these key socioeconomic goals, the socioeconomic goals are meant to prevail. It led to a famous saying in legal circles.
What's that?
Where Article 31C comes in, Article 14 goes out. It's a stark but accurate summary of its power.
That really does lay bare the central tension in the entire Indian constitutional project, this constant, difficult effort to weld classical liberal rights onto a powerful engine for social justice.
A messy but arguably necessary balancing act for a country like India.
This has been an incredibly deep dive. Just to recap, we've gone from calling Part 3 the Magna Carta of India. We've looked at the political firestorm that led to deleting the right to property, and we've detailed the incredible power of those 5 writs.
We've seen that these rights are qualified, not absolute, and that the courts act as the umpires, judging the reasonable restrictions. And we've established that the ultimate firewall protecting them is the basic structure doctrine, that brilliant judicial innovation.
I think for me, the most powerful takeaway was the sheer scope of accountability under Article 12. The idea that the state isn't just a ministry, but includes giants like LIC and ONGC and even private contractors. That changes how you see public power.
It does. And we see that this broad accountability is then balanced by the pragmatic complexity of the exceptions to equality, especially Article 31C, which shows the Constitution making tough choices, prioritizing social goals over individual rights in specific situations.
It really is a living document, full of checks, balances, and priorities. So what's the final thought the listener should take away from all this?
I think it's that the real power of these rights isn't just in the text. It's in the constant, ongoing conversation and conflict in the courts that defines their boundaries. What is a reasonable restriction? What is the basic structure? It's a never-ending dialogue between the law and political power.
That engagement is the lifeblood of it all. So for you, the listener, we want to leave you with one final thought to mull over, and it comes straight from our discussion on Article 12.
Given that all these government-linked corporations and even private agencies performing public duties are bound by the Constitution, how should that change your expectations? How should you, as a citizen, think about your right to non-discrimination and transparency when you're dealing with your electricity provider, a public university, or any agency that looks private but is really an arm of the state?
Think about the implications of that broad accountability.
Mull it over until our next deep dive.
Thank you for joining us. We'll see you next time.